Happy Friday. Anyways, just wanted to get back to you regarding the differences between your rights in town as opposed to out of town as it pertains to water draining onto your lot from your neighbor's lot and the remedies and the problems that you could occur, and also a solution for some landowners who typically don't have the protection of the Municipal Act. So let's just touch on this briefly. Under the law, waters naturally occurring surface water, rain, does not have really the right to be collected or not be collected. It's just water. It just does what water does. So whether or not you can get into problems if you alter your lot and increase the amount of water going onto your neighbor's lot will depend on a couple of things, including how the water is collected and where you are. So let's say you're in town. Okay, you're in town. Your lot is slightly higher than your neighbors. You've got a couple of rough spots on it, and you want to grade it up a little higher, a few inches, just to even it up a bit. Now, that's going to increase the amount of rainwater that goes off your lot onto your neighbor's lot and down the road a little bit, but that's considered uncollected surface water, so there's really no problem there. On the other hand, if you were to, let's say, direct all the water through a downspout onto your neighbor's property, that's a different issue altogether. You can't do that. Also, if you were to install some type of a barrier which would prevent the water from being absorbed into the ground, again, you're now concentrating water. So typically when you have rainwater, for instance, you have a 32 or 33% runoff rate. Okay, water runs away. Pardon me. But if you pave it, that increases to around 92%. So just imagine now you have a space, let's just say a 50 by 100-foot lot, I don't know, and you decide to pave the whole thing, and you're a little bit higher than your neighbor's vegetable garden. You've now increased the amount of water going from your lot to their lot by three times, which means you could flood out their lot if they have no way of draining that as well. And then that goes down the road, and their next neighbor could have a problem. So in town, it's a little different because you have the Municipal Act. The Municipal Act says that you can call the municipality. They can come by and say, look, what you did there, yeah, not good. You have to fix that. All right. Or provide some kind of a remedy to enjoy your land while you also prevent damaging your neighbor's property, which means that you cannot collect the water and concentrate onto your neighbor's property. So you might be required to put in a little ditch and put a spout going to the front of the house or something to the municipal drain area. Now, if you're out of town, it's a bit different because the Municipal Act doesn't really cover you. They only cover the portion of the road that's owned by the municipality. So usually that culvert in the front. All right. So if your neighbor decides to pave a large part of the back lot, let's say they want to put up a tennis court or something, and then a slab patio, and let's just say it covers 50 by 150 feet. I got to pick a number here, okay? For that area there, the amount of water that's running off that area is now tripling onto your lot. And if you have, a swale in the back or something, or a little burn or some kind of a ditch, it might just run off and go down the road and into a stream, and you don't care. But if it's going right into your actual lot, onto your septic field, or it's hitting your top of your well casing, it could have detrimental effects because again now you're getting runoff, but you're also getting chemical runoff because of the asphalt and everything else, which if it's running across your well could seep into your well water. But the point I'm trying to make is that you, as a landowner, do not have the obligation of accepting water from your neighbor's lot. So you could put up a burn, a wall, send the water back, even if it causes them distress under common law. But the problem is, this stuff generally, when it gets to the courts, becomes very expensive for everybody. So it might be more beneficial to have some kind of framework, within our bylaws or rules that say that if you want to do some substantial renovation or remediation to your back lot or your lot that's going to, in the rural setting, now we're talking about, that's going to affect your neighbor, then it might be a good idea to have that documented. You've spoken to your neighbor, you explain what they want to do, they explain what the problem is, you've looked at a solution, and it's done. The town has a record of that. Doesn't directly get involved, but has a record of that. And if it ever does go to litigation, then the town can say, we gave them the chance to talk about it, it's not our problem. However, keep in mind that the person receiving the water could go to the town and petition for remedy, which means that the town then would have an obligation to go to the lot, look at it, and if applicable, design a drainage plan, and that cost could be split between the homeowner A and homeowner B. But the problem is that the person who's receiving the water, who didn't want the water, is now having to cough up some of the cost for something that they didn't cause, and that's where I think it's a bit unfair for the real property owner, and that's what I'd like to see changed. So, some type of framework put into effect that will give the receiving landowner some greater rights when it comes to dealing with the problem without it having to go to expensive litigation. That's what I'm thinking. Okay, so we can talk about that. If you have any questions, send me an email. Take care.